The whole world is talking about self-defense because of the Rittenhouse case and the killers of Ahmaud Arbery. But many on the internet are getting it wrong. So today, let's talk about the standard, the difference of jurisdictions, the burden of proof, and how does a firearm change everything. Self-defense, or defense of others, is a sub-defense of justification. Justification is a principle under the law that when your actions may have broken a law in other circumstances, in these circumstances, you needed to do whatever it was you were accused of doing. What follows is not an exhaustive discussion of all things self-defense, and every jurisdiction's self-defense laws are different. But let's go over a general discussion because it may help us discuss self-defense in a more intelligent manner when we talk to each other about these types of cases. Self-defense has a three-part test, and I'm going to use my jurisdiction's jury instruction to help explain. The use of force on or toward another person is justified if the defendant reasonably believes that force is immediately necessary to protect himself or herself on the present occasion against the use of unlawful force by the other person. The reasonableness of the defendant's belief that the use of protective force was immediately necessary shall be determined from the viewpoint of a reasonable person in the defendant's position under the circumstances of which the defendant was aware or as the defendant reasonably believed them to be. Now that's a lot of words and that's a mouthful. And that's not even the whole self-defense jury instruction. But it comes with a three-part test, and let's see where we get those three parts from. You'll notice the first is the three parts of the test. The subjective standard, the objective standard, and then proportionality of the self-defense. So that the defendant reasonably believes, that's where we get the subjective standard. Let me talk about those three in a second. That was immediately necessary to protect himself. That's the proportionality standard. And the final one is from the viewpoint of a reasonable person in the defendant's position. That's where you get the objective standard. Let's talk about what all three of those mean. The subjective standard is what a person believes in that moment. Are they fearful that they are going to be hurt of self-defense and they need to use some sort of reasonable force to counteract the force that is coming at them? That's what everybody most naturally understands when you think of self-defense. I was scared he was going to hurt me. I had to stop someone from hurting me. The objective standard, though, is what a reasonable person in the same shoes feel the same way with the information as it was known to the person who actually used the self-defense. So it doesn't demand that you have information that you wouldn't have known had you been in that situation, but it does demand that a highly stressed out person or a person who is more scared of every shadow that jumps out of every corner doesn't have some higher degree of ability to attack other people because they're unreasonably scared about certain things. And finally, the last branch of this section of the test is proportionality. You can only use a proportional amount of force in defense of yourself or in defense of others. So for example, if someone is going to push you very softly, you're not allowed to knock their block off and hit them as hard as you can. On the other hand, you would be allowed to if the punch they're throwing at you is very hurtful. We'll talk more about different parts of that later. Let's talk about the burden. Who has to prove it? Is it the prosecution or is it the defense who has to prove this when you get before a jury in this case? Now, this depends on if it's an affirmative defense. If you're in an affirmative defense state, it is the defendant's burden. If it's not an affirmative defense state, it's the prosecution's burden. So in Hawaii, the burden is on the prosecution to prove beyond a reasonable doubt that the defendant was not engaged in self-defense. They have that burden, but this is different in Wisconsin. I also believe it's in Georgia, but I've seen conflicting reports. In an affirmative defense state, the burden is on the defense. They accept that they admitted the charge. That's what affirmative defense means, that they committed it, but it was justified. They had a good reason to commit it. And they have to prove that more likely than not. So this is not the reasonable doubt standard. The defense has a lower standard. They have to prove more likely than not that under the three-part test, self-defense was justified. Now, before we go further, I want to talk about two other principles which we don't normally consider part of the test, but are very, very important. And of course, there's other principles, but for the purpose of this video, I really want to discuss these. Number one is provocation. Let me quote the Florida law. Before I quote the Florida law, the simple way to describe it is, if you start the fight, you cannot claim self-defense. Let me quote the Florida law because I think it makes it a little bit easier to understand. What they write is, if you initially provoke the use of force against himself with the intent to use such force as an excuse to inflict bodily harm upon the assailant, you cannot then claim self-defense. That's been an important issue, and I think it's going to be discussed in both of these high-profile cases that we're discussing around the country. Finally, deadly force is important, as there is, unfortunately, always at least one dead body in each of these cases. Deadly force is very clearly an issue here. Now, deadly force in a model penal code state, so I'm not certain that this is the same in Georgia, Wisconsin, but in a model penal code state, deadly force is only available in situations where you reasonably fear of rape, sodomy, death, or severe bodily injury. Now, as I said, clearly deadly force was used in both the Georgia and Wisconsin case because there was a dead body. So how do guns change everything? Let me show you two passages from my local jury instructions that I think are very helpful to help clarify gun charges. The first on the left tells you what happens if someone uses a firearm, intentionally firing a firearm in the direction of another person or in the direction which the person is believed to be constitutes deadly force. We've all seen the movies or seen the TV show where at some point in the course of the TV show, the person says, well, I shot him in the leg, and since I shot him in the leg, I wasn't trying to kill him, so you can only get me on assault with a deadly weapon and not attempted murder. That's clearly false. Any use of a firearm firing in the direction of another person or in the direction which the person believed to be constitutes deadly force. And again, this can change according to statute. There's certain states, I believe Georgia might be one of them, but I don't want to say for sure, where a warning shot as well, a warning shot maybe directly up in the air. I think Florida is the famous case about that. A warning shot directly up in the air can still be considered use of deadly force. Let's look at the blue side of the screen. This is also very interesting what happens when guns are involved. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, so long as the actor's intent is limited to creating an apprehension that he will use deadly force if necessary, does not constitute deadly force. What that means is, by brandishing the weapon without pointing it, without threatening, without doing more, without actually using it, you may be able to say that you didn't engage in deadly force. What you just did was attempt to create an apprehension that you will use deadly force and therefore did not exacerbate the charge up to that certain situation. That's something that may be very important, especially in the Arbery case. So subscribe to the video, argue with me in the comments, comment below, ask questions if you have questions. If you have a local attorney in your jurisdiction who wants to join me on these videos, I'm happy to talk to them. It's great recently to see so many people involved in their legal system and interested in protecting their constitutional rights.